Hello and good morning, everyone. Welcome to today's webinar on a topic of utmost importance in the legal landscape of India: how to get bail for your clients. In a country where the principles of justice and liberty are paramount, understanding the nuances of bail procedures is crucial for every legal practitioner. Join us as we delve into the intricacies of bail applications, exploring the legal framework, procedural requirements, and effective strategies for securing bail for your clients. This webinar promises to equip you with the knowledge and insights necessary to navigate the bail process with confidence and competence. Get ready to empower your practice and uphold the principles of justice as we embark on this enlightening journey together. It is with great pleasure that we introduce you to a luminary in the realm of criminal law, someone whose expertise and experience are truly unparalleled. Meet Veerta Bajwa, a distinguished criminal lawyer practicing in Mumbai for over 14 years. With an illustrious career marked by a profound understanding of criminal trials, Veerta has navigated through the complexities of the legal system with fineness and acumen. Her journey is not merely defined by years of practice, but by her pivotal role in assisting her senior during the historic 1993 bomb blast trial, along with handling an array of high profile cases that have left an indelible mark on the legal landscape. As we embark on this webinar journey, prepare to be enlightened by the insights and wisdom of a legal luminary whose name resonates with excellence and expertise in every courtroom that she graces. Over to you, ma'am.
Thank you so much, Swatuleka, for this. So, good morning, everyone. Now, today we will be covering up on how to draft. The last session said that there are three criminal acts which every criminal lawyer needs to know: the Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act. Now, from the 1st of July, all the three acts are going to be replaced by the new acts, which are called as the Bharatiya Nyaya Sanchita, which is called as the BNS for short, which will be replacing the IPC, the Indian Penal Code. Then we have the Bharatiya Nagarik Suraksha Sanhita, which will be replacing the Criminal Procedure Code, and Bharatiya Sakshay Act, which will be replacing the Indian Evidence Act. All these three acts are going to have a prospective effect. That is the reason we'll be covering up both the acts, the old ones also and the new ones also, in all our sessions. Now, coming down to your bails, what is the section for bails under the earlier act, under the CRPC? You have two types of bails. One we call as a regular bail. Second we call as an anticipatory bail. We'll be covering up one by one both of the topics today. First, we'll be covering up regular bails. That what exactly do you mean by a regular bail? In what circumstances can you apply for a regular bail? And what are the factors to be argued before the honorable court whenever a person argues for regular bail? Now, regular bail means when a bail when the accused is already arrested and he is in judicial custody. Okay, so that is what you mean by regular bail. He is already arrested, he's in jail. Judicial custody means that he's already in jail. Whenever an accused is already in jail, you will apply for regular bail. Now, under the earlier act, that is covered under two sections. One is section 437 of CRPC, which means which deals with bails before the magistrate. So, whenever an accused is arrested and whenever the offences are magistrate triable, you file for bail before the magistrate, and that would be covered under section 437 of the CRPC. Under the new act, the section now is section 480. The definition under the old CRPC and the definition under the BNSS Act is one and the same. Okay, so there is no changes. So the understanding of the law, the application of the section would be the same as it was in the earlier law. Now you have another section for regular bail, which we call as section 439. CRPC. Now, what do you mean by Section 439? Section 439 deals with regular bail whenever you want to file for bail before the Sessions Court and the High Court. So, whenever an accused is arrested and the offence is a magistrate triable, you will file for a bail before the magistrate. Your bail application title will read as Application for Bail under Section 437. Similarly, if the magistrate rejects your bail or if the offences are sessions triable and the magistrate does not have the power to grant you bail in a sessions case, you will directly approach the sessions court for seeking bail. That bail application will go under section 439 of CRPC. Similarly, when the sessions court rejects your bail application, you will against that order, you will go before the High Court and that section will again be section 439 of CRPC. Now, under the new act, that section is section 485. Okay. Now, coming down to your regular bails, what are the factors? When do you apply for regular bail? What are the reasons and what are the grounds for regular bail when you can apply? Now, whenever an accused is arrested, he is to be produced before the nearest magistrate within 24 hours. That is mandatory as per law. That within 24 hours, the accused is to be produced before the local magistrate. In the event the accused is not produced before the local magistrate within 24 hours, that would amount to an illegal detention of the accused. Whenever an accused is produced before the magistrate, that procedure of production is called as a remand. Now, whenever the accused is produced in remand, during that time, the police files a remand report before the court, giving out reasons that what exactly is the offense which has been committed, what are the sections which has been levied against the accused, what is the role of this accused, and why this accused has been arrested by the police. They have to specifically mention that during the course of investigation, what was the role which was attributed to the accused, what is the offense which has been committed by this accused, and prima facie why he has been arrested by the police, and whether they require his custody or not for further investigation. In case they require his custody, they will be seeking police custody. In the event when the magistrate, if he is satisfied that no, the police custody of the accused is no longer required, the magistrate may remand him to judicial custody. Now, your bail comes into power. You can seek orders, you can exercise your right for bail only and only after the accused has been remanded to judicial custody. The reason being because when he is in police custody, there is a presumption of the law that the investigation is not over, investigation is still pending, and that is why the custody of the accused is required. Once the police custody is over and he's remanded to judicial custody, you can immediately file for bail for the accused. Now, once when you're filing for bail for the accused, okay, in regular bail, the factors first, the first things first you have to mention that on what reasons your client has been arrested, whether there was some recovery, whether he was arrested on the spot, whether some co-accused had made any statement against him on the basis of which he was arrested. Now, whenever an accused makes a statement before a police officer, always remember that statement amounts to a confession before a police officer, and that is hit by section 26 of the Indian Evidence Act, which clearly says that confessions made before a police officer are inadmissible in law. So, whenever an accused is arrested only on the statement of the accused, he, that statement cannot be proved under law during the course of trial against him because it will be hit by Section 26 of the Indian Evidence Act as it will be inadmissible. The other factor which you need to notice, which you need to consider is that what exactly is the recovery from your client. For example, if it is an offense of say dacoity, or if it's an offense of say, theft, so or if it's an offense of murder, you need to see that what was the recovery made at the instance of that accused. Now that recovery is under section 27 of the Indian Evidence Act. So whenever you see a charge sheet, you will see that there will always be a discovery panchnama under section 27 of the Indian Evidence Act. The discovery panchnama basically means the recovery which the police does from the accused when they arrest him. That recovery, whether they have recovered any weapon from him, or in the case if they have recovered any clothes from him which are blood stained, or they recover in the case of theft or dacoity, if the stolen goods have been recovered from him, or in the case of conspiracy, okay, phones are seized and there are CDR details, there are all data records which show that this accused was constantly in touch with the co-accused, and this whole conspiracy was, enumerated by him, or he is only a person who is just made a scapegoat, or he is a person who is in conspiracy but he is not the main mastermind, or whether he is the main mastermind. The role of the accused is of the utmost importance when dealing with bail applications. Always remember this. Then you also have something which we call as a test identification parade. Now, what exactly is a test identification parade? A test identification parade is whenever an accused is arrested, the eyewitness, the complainant, goes to the jail. Okay, 10 dummies are made to stand, in which one the accused will stand, and nine dummy people will be made to be stood in the line, and the complainant has to identify from the 10 people that who is the accused. It's not necessary that the number is going to be 10, and the number can be 6 also, can be 7 also. It's not mandatory that it has to be 10. Okay, so in a line, the accused along with the dummy people are made to stand, and the complainant is made to identify the accused. This is called as a test identification parade. Short form, we call it as the TI parade. So you have to see whether the complainant has identified the accused in the TI parade also. In the event the TI parade is not conducted, that means there is no identification of the accused. That too would come in the favor of the accused while seeking bail. The third factor which you need to notice is whether this case has been filed against the accused as a personal vendetta or to take out any personal grudge. Whether there was some earlier dispute in between them, because of which that there was a personal vendetta in between them, and so as to take out their personal grudge, the complainant has gone and filed this case. Then you also need to see various factors, whether the sections which has been levied, whether that section would be applicable or not. For example, as said, the if I say that if I'm alleging rape under 376, but if it was a love affair, it was a consensual relationship, and the complainant, the victim, she knew the accused and she has gone with the accused multiple times and indulged into a physical relation with her consent, but now she's alleging that it is rape. So these all factors you need to mention and point out to the court that it was a love affair and which has gone sour. There has been some disputes because of which now she, as to remove a personal grudge, she has gone and she has filed a case of rape against the accused. So various factors you have to see whether if I'm managing so 376 whether it is applicable, not applicable. If I'm managing section 420, say of cheating, you need to see whether there has been some what does section 420 of IPC say? It clearly says dishonestly inducing delivery of a property. Okay, dishonestly, that means you cheat a person and you have dishonestly cheated him. Whether those factors, whether the accused benefiting from that cheating. For example, if I am saying that I have cheated somebody and I've extorted, that person goes and alleges that he has extorted money from me. Whether I am the beneficiary of that money, whether that money has come to my account, whether I have benefited from that cheating, all these factors are need to be seen. Another example I will give you, for example, of counterfeit currency. If you guys remember, recently, few years back, there was a lot of circulation before demonetization. In fact, there was a lot of circulation of counterfeit notes in the market. Okay, there were a lot of cases which were being filed of counterfeit currency. The law for counterfeit currency is very clear that whenever an accused is caught with counterfeit currency, he should be using that currency for circulation in the market. The RBI rule says that in case there are four notes of counterfeit currency seized from a person, only four notes. If he goes to the bank to deposit and there are four notes, then only those notes are to be destroyed and a memo is to be issued to the person who is in the custody of those counterfeit currency. But if the number of the notes exceeds beyond four, okay, then an FIR is to be immediately registered for an offence of counterfeit currency, which is under section 485 of the IPC. If that is the case, if an FIR is registered, then it is the onus of the police to prove the prosecution that the complaint or the accused was using that notes for circulation in the market so that there could be a distribution of those notes which could hamper the economy of a country. So all these factors are to be noted, all these factors are to be considered at the time of regular bail application. Always remember, as I said, as per Schedule 1 of CRPC, if you see the table classifies clearly what section, what is the offense, what does it mean, it is triable before which magistrate, what, as I had explained, what do you mean by triable, by which court, there are certain offences which are triable only by a magistrate. For example, your offences such as 498A, those are magistrate triable. So, for a trial of 498A, that trial will be conducted before the magistrate. But if along with the offences of 498A, say section 307 or 302 or 376 is alleged, which are sessions triable, then the trial will be conducted before the sessions court and not before the magistrate. So section 437 deals with bails before magistrate, in which all the offences have to be magistrate triable. In the event if a person is alleged with say 4 to 5 offences, out of which even if one offence is sessions triable, the trial, the bail application will be first. The first bail application will always be filed before the sessions court because the magistrate does not have the power to grant bail in offences which are sessions triable. Okay. Now, coming down to your bail applications before the magistrate. Once you file the bail application, as soon as you file the bail application before the magistrate, you will put a full title, full cost title. Along with the title, you will give a brief background, a brief history about the offences about the incident which has occurred as per the FIR. But what exactly is the incident, what has occurred, and why the complainant has filed this case and why registered this FIR. Then you will mention that what was the investigation which was being conducted by the police, and during the investigation, why the police has arrested you, on what grounds have they arrested. Say, as I said earlier, if they arrest you only on the statement of the co-accused, so you will mention that the accused was arrested as per on the statement during investigation, the accused number one or accused number two, so and so, Mr. So and so, in his statement before the police had taken the name of the accused and alleged, given allegations and attributed a role to him, on the basis of which the investigating officer had arrested this applicant, has arrested this accused. Now, in the event if there are no other allegations except the statement of the accused, then it's a clear-cut case for rape. Similarly, when we go for rape cases, you have to always see the medical of the victim, the age of the victim, the allegations, whether it was a love affair, it was consensual. Then you need to see the medical. Medical, you will have to see whether her hymen was torn or not. Well, what is the position of the hymen? You have something which we call as a 6 o'clock position. Now, what do you mean by a 6 o'clock? If you see the clock, what does six mean in a single line? So if there is an insertion, if there is a 6 o'clock position, that means that the victim was subjected to penetration and there was an intercourse with her. Similarly, her medical needs to be seen, that what exactly are the injuries on the victim, whether the injuries are very grievous, whether the injuries are corroborating with her statement. Now, you have something which we call as corroboration. Now, what do you mean by corroboration? Corroboration means that whatever the victim says, that has to corroborate with the evidences. Corroborate means it has to link with the evidence. For example, if the victim alleges that she was assaulted with a knife, then there should be injury of a knife on her body, and the medical should say that there is a cut, there is an injury of a knife. This is called as corroboration. In case of the injuries, there is no cut, okay, and there are no that the cuts are called as CLWs. We call them CLWs, which are called as contusion lacerated wounds. Whenever you cut a person, those are called as lacerated wounds. If there are lacerated wounds, then that corroborates with the knife. But only if there are abrasions. Now, abrasions basically mean that you go and you punch a person, and then the person gets a mark. That's called as abrasions. If there are only abrasions, then that would not corroborate with the statement that she was assaulted with a knife. So that will again come to your favor. Similarly, for cheating, for forgery, if you're alleging forgery, there should be a forensic report to substantiate your claim of forgery. One. Secondly, you should be the person who has committed the act of forgery, whether you are the person who has forged those documents. All these factors are to be argued before the bail court. One thing always, always, always remember, please, that whenever you're arguing for a bail application, always argue with the evidence which is before you. If you are arguing before filing of charge sheet, please constrain yourself to the FIR. If you are arguing after filing of charge sheet, please constrain yourself to the investigation conducted by the police and the evidence collected by the police. Do not go beyond that. Do not say that the police has not conducted this investigation. Major, you will see a majority of the times, this is a common mistake which a lot of people do, is that they start arguing and they start saying that the police has not collected the CCTV footage, they haven't collected the CDR, they haven't done this investigation, they haven't done this investigation. Do not do that. Always point out the lacunas in the investigation conducted and in the charge sheet filed before the court. Do not take out the lacunas in the investigation, the discrepancies which they haven't done. because that is something which is their fault. And if you're going to point it out during the time of bail, you are going to give an opportunity to the police to come up and cover up. Save and except if there is a plea of alibi. Now, what do you mean by a plea of alibi? An alibi means that if there is a murder committed, and when I say that I during the time that the murder was committed, I was not there. I was at some other place. This is called as a plea of alibi. In case there is a plea of alibi, you can take that. You can produce your evidences to that effect, because whenever there is a plea of alibi, it is a duty of the police to go and conduct that which they haven't done. So whenever we always go down to the bail application, you will always file the full title, then you will give the facts of what exactly is the offences which has been conducted, the role of the accused, and then you come down to your defense. What exactly is your defense? Why the prosecution case is not maintainable, and why you need to be granted bail. Then this is called as regular bail application under section 437 and section 439. Okay, this is what your prayer goes as. Whenever you file a regular bail application, your regular bail application prayer clause to always go as that that this honorable court be pleased to release the accused on bail in FIR number so and so, registered by so and so police station under what section. You always have to mention that this interim bail. We will not that this prayer clause does not come in the regular bail application. This only comes if you are seeking an interim bail. Now, what do you mean by interim bail? Interim bail basically means as temporary bail in regular bail application. Okay, it means temporary bail to an accused, and there are various factors in which they can be granted temporary interim bail. The majority of it being medical reasons, that he is not well, or somebody in his family is not well, because of which there is nobody to take care of him, the person, and he is the only person who has can take care of that person, and that is why he needs to be released on interim or a temporary bail. And you will have something which we call as whenever an accused is released on bail, he has to furnish surety to that effect. Now, what exactly is a surety? A surety is basically a guarantor, a person who stands before the court and gives a guarantee that this accused will not abscond, will remain present during the course of trial, and it is my duty to make it sure that this person attends the trial. In the event if this person runs away or if he absconds, I will catch him and get him before the court. And why the surety says this? Because in the event if the accused is absconding and the surety notice is issued to the surety that where is the person you stood as a surety for, and if that surety is unable to produce the accused, his properties are attached so that he goes and he gets the accused before the court. This is what regular bail application means. Now, coming down to your anticipatory bail application. Now, what exactly do you mean by anticipatory bail application? Anticipatory bail application means, as the word says, whatever you, if in the event you are anticipating that you are going to be arrested. You are not arrested, you are not in custody, okay? But you are anticipating that you are going to be arrested. You are anticipating that you are going to be arrested by the police, and that is the reason you want that you should be protected before you are produced before you be protected before you go before the police. That is what anticipatory basically means as. If you read the judgment of Gurmeet Singh Sibhi of the Supreme Court, In the judgment of Gurbaksh Singh Sethia, the Honorable Supreme Court has clearly said that whenever a person anticipates that he is going to be arrested, he has a reason to believe that he is going to be arrested, and FIR is not necessary mandatorily that it has to be registered. Now, when you come down to regular bail applications can be taken in bailable offences also and non-bailable offences also. But when it comes down to anticipatory bail applications, those applications can only be filed for non-bailable offences. And anticipatory bail applications are filed under Section 438 of CRPC. Why only non-bailable offences? Because in bailable offences, you are going to be immediately released on bail. They cannot keep you in custody. But in non-bailable, they can arrest you and keep you in custody. And that is the reason you have the provision of anticipatory bail under Section 438. Now, as per Gurvaksh Singh Sethia, the Honorable Supreme Court has said that if a person has a reason to believe that he is going to be arrested, he can approach the Honorable Court and seek anticipatory bail. That is filed under Section 438. Powers of anticipatory bail are only and only one with the Sessions Court, second with the High Court, and in the event if the High Court also rejects it, then you go to the Supreme Court. But your first bail application for anticipatory bail is always filed before the Sessions Court. The Sessions Court has the power to grant you anticipatory bail. So if you directly go to the Sessions Court, magistrate does not have power to grant you anticipatory bail. So your bail application under Section 438 would never ever be filed before the magistrate. It will be filed before the Sessions Court. Once you file an application for anticipatory bail, the first and the foremost thing which you need to satisfy the Honorable Court is that one, why the offences are not made out against you, and second, whether your judicial interrogation is required. That is the first and the foremost thing you need to explain in an anticipatory bail application, whether you need to go in jail, whether you need to go into police custody for investigation, or you are ready to cooperate with the police and you are ready to cooperate with them in the investigations without going into custody. This is the first and the foremost thing you need to satisfy the court that why your judicial interrogation should not is not required. In an anticipatory bail, the grounds of bail are totally different than regular bail. In regular bail, you're already in custody and you are satisfied the court that why your further incarceration is not necessary, why as per the uh, investigations conducted, you don't need to be in custody, and that is why can be released on bail. Whereas in anticipatory bail application, what you need to do is you have to first satisfy the court that why you're not required to go to the jail at all under the anticipatory bail application. One. So whenever you file a bail application, you will always specify that what are the offences. Then you have to specify that why this case has been filed. Most of the times you would see that under the anticipatory bail applications, that majority of the time the cases are filed as a personal vendetta. For example, offences under 498A. Under 498A, majority of the cases, you would see that there may be a divorce petition, there may be filed, and there may be allegations which will not substantiate any act of domestic violence, and that is the reason we go to the court seeking anticipatory bail. As I had explained under 420 also, now if you there is one judgment of the Honorable Bombay High Court, which Sham Bhatia's judgment, which clearly says that when offences are relating to documents, the custody of the accused is not required. That means that when there are offences of forgery and there are offences of 420, the offences are all relating to documents. Okay, it can be made out, it can be uh, substantiated through documents, and for which the accused does not need to go into custody. This judgment clearly says of Shankhatia, so that when the documents speak for itself, and that is why the custodial interrogation of the accused is not required. In such scenario, you can seek anticipatory bail saying that the offences maybe are civil in nature, offences are relating to documents, and I don't need to go into custody. I can be granted anticipatory bail. As I said, in the cases of rape cases, whether they were love affair, it has gone wrong. The the physical relations were consensual, and that is why I may be granted an anticipatory bail. Now, once you file for anticipatory bail application, you will mention your facts, your drafting, your bail application format goes as the same. Your facts will go, your stand, your defense will go, and the grounds. Your grounds are whatever defense you take goes exactly in short in one line. You will mention as grounds. Only the prayer clause changes in an anticipatory bail application. In an anticipatory bail application, you will write that in the event of arrest, in the event of arrest, the applicant be released on bail. Okay, so when we were talking about regular bail application, our prayer clause goes as that the applicant be released on bail. But when it comes down to anticipatory bail, you will write in the event of arrest, that means if he is arrested, the applicant be released on bail in CR number so and so for offences under section so and so filed registered by so and so police station. Okay, on such terms and conditions. Then you also have interim protection under the anticipatory bail under section 438. What do you mean by interim protection? Whenever you file an anticipatory bail application, of course, the application is going to take time for hearing. So you need to be protected till the time your anticipatory bail application is not heard. That is called as interim bail. Okay, interim protection. You need to take that interim protection from the court, because in the event if the pendency of the bail application you are arrested, your anticipatory bail application will become infructuous. So you will have to go, and then if your anticipatory bail application is pending and you are arrested by the police, then that anticipatory bail will not stand. You will have to go and seek regular bail before the court. That is called as interim. So whenever we file an anticipatory bail application, an interim application goes that you be released on bail. Interim in lieu of prayer clause A may kindly be granted. Interim relief in lieu of prayer clause A kindly be granted. You will always write that. The court will give you an interim protection that till the pendency of this ABA, you will not be arrested. In the event you are arrested, you will be immediately released on bail. That's what anticipatory bail means. So, basic difference is in regular bail you are already in custody. Anticipatory bail you do not want to go into custody, and that is why you have to satisfy the honorable court that why before going into custody, why you need to be released on bail. Am I clear? So this sums up your today's topic on bail applications. This is how you draft your bill. The prayer clause changes. Regular, you will say that he be released on bail, whereas in anticipatory, you will say that in the event they are arrested, they need to be released on bail.
That was very insightful, ma'am. Ma'am, I have some questions if I can ask. Okay, thank you. Thank you, ma'am. So, for anticipatory bail, suppose there's only apprehension based on a complaint, okay, but no FIR has been yet filed by the police. But the police now refuses to give a copy of the complaint. How do we file for anticipatory bail in these
See,
cases?
they will always issue you a notice. Whenever they will issue you a notice and they'll call you for investigation, saying that there is a complaint which has come against you and you need to come for investigation. The complaint copy, of course, they don't give it to you. What you can do is you can file an application under RTI and get the copy of the complaint under RTI. Once you get the copy of the complaint under RTI, you can go for anticipatory bail. Gurbaksh and Sibia is very clear. It clearly says that it is not mandatory that an FIR has to be there. Even on the basis of complaint, even if there is a complaint and you have an apprehension that the person is going to be arrested, you can seek anticipatory.
All right, okay, ma'am. So, if anticipatory bail is rejected in session court and high court, under which CRPC section or any other section can we approach the Supreme Court?
Goes into the Supreme Court in SC.
Okay, all right, okay, ma'am. All right. And if accused is suppose committed a special act offense, right, as well as committed the offense which is triable by the session court, then by that said accused, how does the said accused obtain bail in which court, either special court or session court?
The all always remember this that all the special acts which have been enacted, you will always find under the act that an additional sessions judge is appointed as a sessions as the special judge. For example, if you see NDPS, only an additional session judge has the powers to try an offense under NDPS, and he is appointed as an NDPS special judge. So those special judges are sessions judges only. So your bail application goes before the special court.
All right, okay, ma'am. Thank you, ma'am. Thank you for the insightful session, and I hope everybody has enjoyed the session. So, that was about today's session on how to get bail for your client. Thank you, everyone.
Thank you.